What is the most common estate planning mistake you see families make?
What would you say is one thing that you hope every listener would take away from our conversation?
That you are planning. You are planning. You're doing something.
Welcome to the Empowered Elder Podcast. Aging doesn't come with a manual, but it does come with questions. The Empowered Elder Podcast gives you clear answers, trusted professionals, and real resources that are going to help navigate life's later chapters with confidence. Because you don't have to do it alone.
Caring for an aging parent or loved one can feel overwhelming. The Empowered Elder Podcast connects you with experts, answers, and resources that ease the journey. Because aging doesn't come with a manual, and neither does caregiving.
Welcome to the Empowered Elder Podcast, where we explore what it really means to age wisely, to live fully, and protect what matters most. Today, we're diving into one of the most important and often misunderstood topics that families face, which is estate planning. Across all U.S., adults, just 31% have a will and only 11% have a trust. And whether you're thinking about writing your first will, setting up a trust, or simply trying to avoid the pitfalls that can cause conflict down the road, this conversation is for you. Our guest today is Dan McKenzie, founder of the McKenzie Law Firm in Centennial, Colorado. Dan has spent years helping families turn complicated legal planning into something meaningful, a way to protect their loved ones, and also their legacies with confidence and clarity. After a decade as a litigator, Dan realized he wanted to help families prevent conflict rather than repair it, and that perspective has shaped everything about his approach to estate planning. Together, we'll explore the difference between wills and trusts, the biggest mistakes to avoid, and how to make sure your family is protected long before a crisis ever happens. Because as Dan says, planning isn't just about paperwork, it's about peace of mind.
What allowed you to shift your focus to preventing conflict instead of cleaning it up afterwards?
I think just exhaustion at the cleaning it up, right? Just the constant fighting. Like every day you walk into work and it's like you kind of have a plan of what you're going to work on and it's like firefighting constantly. Some people really get energized by that. It's like the introvert-extrovert thing. Like some people get energized by talking to people, some don't. Like some people get energized by the conflict and love it. My boss, is completely like he would never do what I do. I mean, that would be totally terrible for him. He loves to fight.
Gotcha.
I don't. I'm not a conflict person. But even, in estate planning, there's still this underlying, conflict all the time in law. Yeah. I think you guys deal with it too, right? I mean, I had a friend who was a realtor for a while. He was one of those pop in and pop out types. Like it was like, I don't know how long he did it, but he's not a realtor anymore. But he was like, yeah, it's actually technically like a law license just to practice this one particular area of law. But like, I'm sure you get into conflict all the time.
Every day.
Yeah.
Every day.
It's uncomfortable to have some client who is demanding stuff and then you got to deal with the other person too. And it's like, trying to mediate that is exhausting to me.
Did your litigation background kind of shape your philosophy about estate planning?
Yeah. I mean, it certainly helps to see like how that works and what's possible, and just more on the estate administration side, frankly. Get a ton of people who come to us who are like, I've been seeing a lot of personal injury ads where it's like, you don't pay unless we win. And like, that's a personal injury thing. You're going to have to come up with $50,000. You don't just get to like allege that the will was, unduly influenced or something like that. You got to actually have to prove that. Mm-hmm. And you're going to have to get doctors to say that this person couldn't, do this.
They weren't competent to make a decision.
Mm-hmm. They're going to charge $600 an hour. You got to pay for that.
Mm-hmm. Yeah, right.
I'm not paying for it. And then, maybe getting something if we win. We don't even know what's in this estate. So that is very helpful to have that just procedural knowledge of what it actually takes to do something. But yeah, I mean, I think just definitely, a lot of people have ideas that are like, disinheriting someone. I'm like, well, you're not going to be here for that anger to be unleashed on.
Mm-hmm. True.
Mm-hmm.
So, it might make you feel good to write this down, but just be aware that it's going to be vented at your other kids.
Yeah.
And a lot of times we're speaking with people and they think that maybe estate planning is for the wealthy only, or, maybe I'll do it someday. How do you, in your conversations with people, kind of change that framework and let them see it a little bit differently and how it can be beneficial?
I mean, I think a big part from us is just really talking about the incapacity planning. Everyone's very focused on death and who's getting my stuff. That is not your biggest risk. Your biggest risk is having some event where you can't do stuff. And like I always tell people, I moved here 10 days before my wife did. So I was here for the closing on our house. She was not. So I had to get power of attorney from her to do that and sign all those documents twice.
Did you ice your hand at the end?
I mean, yeah, I have PTSD from that. Like, not only do you have to sign it, you have to write as agent for, this for like, it's, write a sentence on 70 different pieces of paper. But it's like, she was fine. She just wasn't here. And like, I can't get her medical records. I can't, maybe in an emergency, they'll probably turn to me and ask. But anything that's not a complete emergency, like, there's no way they're going to let me participate in her medical, and vice versa. For single people, that's even more acute, because even in an emergency, who are they going to talk to? So that's usually what I focus on when I get somebody really it's not really important. It's like, you're probably going to have an incapacity event, and that can happen at any moment. Maybe you'll be lucky enough. I don't know. Is it lucky to see death coming? I don't know.
That's a question.
At any rate, yeah, maybe most people kind of sense I'm going to die soon. Like, it's very tragic when someone dies unexpectedly and notable. But people get hospitalized unexpectedly all the time. All the time.
Absolutely. Or if they say, I don't have anything. Like, there's really nothing. Like, you can just take whatever there is. There isn't much of it, but it becomes, that's not the only
I've
issue.
had some crazy fights in estates that were really pretty modest, under $300,000.
Interesting.
The worst one I ever had involved a house in Westminster that was I think it's maybe 900 square feet. I mean, it's just one of those tiny little, what do you call them, bungalow type places, very working class community. I looked at it on Google Maps and work trucks all over the parked on the street, because it's this is a working class neighborhood. And this house, you wonder how it's not falling down. I mean, it's the paint is chipped. They're literally wood jammed under the back porch, because I think the porch probably had sunk and they needed to support it.
Right.
Weed strewn yard, and then holes in the ceiling because rain had gotten in. The roof badly needed to be replaced. We went to appellate court on this house. Appellate court, this never happens in the probate world. So, I mean, if you get someone out there determined enough, her lawyer kind of got rid of her, I think, because you do not have a valid position here, but she strung it out all the way to appellate court.
Well, and that really ties to the conflict and the process. So it's not just about documents, right? It's about preserving relationships and trying to avoid conflict and maybe clearing up some confusion.
I mean, among people who specialize in this, we always kind of say the documents are free. I'm not charging for the documents. You don't know. I always tell people, in law school, the worst thing that could happen is if you walked out of an exam thinking you knew what you were doing. You better have been confused, because it's in law, it's what you don't know. You don't know what you don't know. And if you think you know, it's probably because you're an idiot, right? I mean, it's what do they call that? The Dunning-Kruger effect. And that's most people, they do not understand the interaction between joint ownership and designated beneficiaries and LLCs and retirement titling and all the rules around that. And you're asked to make these decisions. It's crazy. A lot of people, especially around here, if you own a home, fairly good chance you're a millionaire on paper. So you're dealing with 7 figures. It's you do not have even basic knowledge about what joint ownership versus, that was what was at the heart of that Westminster case. Joint ownership versus tenants in common.
Mm-hmm. Interesting. And, you find it having to talk through it, but even if you talk through it, sometimes it doesn't really make sense. And you're okay, let's go through this again, or maybe contact an attorney to find out if you still have questions about it. But Just like, let me just check the box and just move on. And,
Yeah.
A lot of times I'd like to talk a little bit about wills and trusts, because oftentimes you'll hear somebody say, well, I have a will. And obviously we're talking about Colorado specific, but they'll say, well, I have a will, so everything should be fine. But you've often said that sometimes a will will lead to probate. So can you talk a little bit about that, just so families can know that there's not going to be any surprises when you say something like that? I have a will, but no probate, right?
Yeah, a will does not avoid probate. Probate, it depends on how many assets you have when you pass away. Right now, the threshold is $86,000 or real estate will tip you into probate. Does not include assets that are jointly held with someone who's still alive. Does not include assets that are designated beneficiaries. Does not include assets in an entity like a trust or a company.
Why do you think families are so surprised when they hear that?
I think that's what they think. Like when they hear estate planning, yeah, we've had a number of people like, I thought the reason we did this will was because we were trying to avoid probate. And they just feel like, it's my family. No one disagrees with this. This is what everyone expected. Like, why do we need to get a court involved? And the answer to that question is, it's not just your family. Everybody has creditors when they pass away. Even if you don't have like debt, bills keep coming. And so somebody's got to deal with that last water bill, cell phone bill, tax filing, HOA, during the time that you're between selling the death and the selling of the house, like you're paying insurance and taxes and HOA dues and whatever else and maintaining it, like who's doing that? So there's just so much more going on than just like, okay, once we sell this house, we're going to take the net proceeds, put it in the calculator, divide it by 3 and write checks. Like, okay, that's easy, but there's just a ton of stuff. What are
the real world consequences when people really just rely on the will?
I think people underthink it. It's really easy to put together a will. Getting back to the point that the documents are free, like you literally can take out a cocktail napkin and write a will on a cocktail napkin. If it is dated and signed and in your handwriting, it will be admitted to the court. And if it exhibits testamentary intent, meaning if it says, like, when I die, I really want, my son to get this sports car. Like, all right, that evidence is testamentary intent. You dated it, you signed it. That is a will. So you can have a very simple document that qualifies as a will. The problem in this area of law is, like, if I negotiate a contract with you, like if you're selling me your house, there's some expectation that you're going to try and do, obviously there's some stuff you have to disclose by law, but maybe you're not going to tell me the neighbor parties till 2 a.m. every morning. Like you're going to put your best foot forward. You're going to paint over some stuff. And I know that, and I'm going to present myself as maybe poorer than I am and try and maybe write you that heart-wrenching letter about, how my kids are going to enjoy this so much. But you're quickly going to find out if you screwed it up, right? You get in that house, it's like, oh, I should have thought about this. Or you sell, and it's like, damn, I could have gotten more money. Like, the house next door sold the next week for like way more. Well, at least you found out. And maybe you can take legal action on that. Now I write a will, I'm never going to find out. I'm never going to find out whether it worked.
Right.
You're not going to find out for maybe decades later. Mm-hmm. We have wills that are like decades old that get put in a probate. It never goes stale. You've got to do something proactive to get rid of a will. And so if you wrote a will, we had a probate recently where the will underlying the whole thing was from 1976. Obviously a ton of people in the will had died. People had been born who were important to the whole thing. Like it was bad. Yeah, people, if they just feel like, I wrote a will, so we're good.
Check that box and you feel like you're good and nothing changes.
Yeah, and people underestimate how fast things change. I always just ask people, like, look, are you hanging out with the same people today that you were 10 years ago? Like, it's not that long ago. Your finances are really the same as they were 10 years ago.
How often should someone revisit their will?
We write our clients every year, just saying, pull it back off the shelf and remind yourself. So doesn't hurt to look at it and remind yourself. It's faster. Everybody who comes in who has a document, I always ask them, well, how old is it? And they're always off by a factor of 2. So if they say it's probably 5 years old, it's 10. No one ever overestimates. I don't think that literally has ever happened. They always underestimate. And I would say, so obviously the change in family through birth, death, marriage, or divorce, anything close in your orbit, that is a good time to pull things up and look at them. Any significant change in assets, a move, or just, an inheritance or a retirement or something like that. But there's no time necessarily. Like, you really could have a 20-year-old will that is fine. I mean, we have some people, it's like, I have one adult son and the will leaves everything to him, and it was drafted in, 2005, and that's still fine. Valid. Yeah. And then we have people who literally got married within a year of doing their plan and really had not planned on doing that. So that's a big change. I was like, this is 9 months old and it's totally wrong now. I would say about, it's for us, we start to see people usually have changes about 3 years after they do the plan is where we start to see things pretty consistently. And it's unusual for people to go 5 with nothing changing. Usually, you've got, you're naming the people in the personal rep and your financial agent, your medical agent, and if you can go at least 2 deep, that's good. So you got a primary person and a backup. So right there, I just listed off 6 different people. Mm-hmm. It's probably, same person holds several different positions, but that changes a lot.
How does the dynamic change if it's a trust-based plan?
I mean, it's, it's not that, I mean, the trust-based planning is just to try and make sure someone can step in and run things without any court intervention, right? So we're retitling everything to this trust. You own the trust, but it's like owning a company. I always compare it to owning a company, and it's a very similar structure. It's just that trusts are for personal stuff, whereas companies are for business and making money. Trusts are for your house and, checking account and stuff like that, where it's you're not really making money off that stuff. So the trust just is kind of a way to create this thing that you're now running, and someone else could step in and run just like you are, without having to go to a court and get some sort of authorization to do that. So it might take the pressure off people, and they feel we got to go to court and disclose things to people, and there's stuff out in the public. So there's reasons to do trust, but you can have a fight. You can, if you're going to come up with a plan that would involve would trigger a probate fight, it probably would trigger a fight in a trust administration too. So it's harder to challenge a trust, and can be harder to get information about a trust if you're intentionally trying to keep someone in the dark. Mm-hmm. Some family member you're disinheriting, or somebody you're giving less to, or something like that. You don't really want them to know. It's easier to control who's knowing what within a trust.
Is there the same trigger, though, for $86,000 in real estate or other assets are triggered for probate with a will? Is there the same trigger for a trust?
I mean, the trust is going to control whatever you put in it. And you can have a trust, and the stuff outside the trust is worth more than $86,000 or includes real estate. You're still going to go through a probate. So there's an epidemic of people out there who created trusts and feel they walked out of the lawyer's office I did it. I'm done. Got my trust and everything's set now. It's no, you got to go put the stuff in the trust. And people don't, I'm sure you see trusts, houses titled to trust all the time. People forget that step. So that's critical. But no, the trust, it's just whatever's in there is, so it could be one thing. You could have a trust that's just we've had people designate beneficiaries on everything, all their financial accounts. It's primarily it's financial accounts in their house. So they can go into the bank or the investment place or whatever else and put designated beneficiaries on all that stuff. And then they got to figure out what to do with the house. If they don't want probate, a lot of times they're putting that house in the trust. The only thing going through the trust is the house. When people do that, I always just point out, you probably should put some cash in there too. The house is going to cost money, like I just said. You got insurance and taxes and stuff to pay for. We've had estates that literally, all the cash got shot out, and it's we're only dealing with this real estate, and somebody's having to loan money back to the estate to facilitate all that. And so that's another where people just they do their own plan or whatever else. It's they do not think about that.
It's kind of like wondering, like, what are the steps if somebody wants to make sure that what they're setting up is clear and accessible. So, and to know, do I just do a will? Do I do a trust? Do I establish that? What are the steps that they take to know, where do you begin?
I mean, obviously there's more available online than ever. The challenge here is, like, a lot of people, I would say a huge majority of people who come to our office are like simple. I really want simple. I get that. Do you want your insurance policy to be simple? Like, do you want the car financing documents to be simple? Like, of course you do, but they're like, a stack like this. Have you ever read your homeowner's insurance policy, like, end to end? Like, you just kind of assume in a lot of cases, like, this probably is right. And the reason is because it's not just like even a will, like, they're thinking about their kids, and the kids, like, it's not just a letter to your kids. The IRS is involved in this. The real audience is probably the lawyers at the bank where you keep your money, and the lawyers at the title company. The title company lawyers are like, they're the toughest ones we have to deal with. Like, as you are probably aware, any defect at all in the title, like a comma missing, is like, this is a hugely problematic thing. If somebody has their full name in one place and then middle initial in the next place, like, nope, cloud on the title. These are the people we have to write this thing for. Mm-hmm. And yeah, your kids are ultimately the beneficiaries of this thing, but their part is this one paragraph that just says divide everything equally between my kids. Well, the bank doesn't really care about that. They care about who has the authority to come in here and take the money out of this account. And we're not real clear. Who has the authority to sell this house? The letters you got from the court have the middle initial on there. This deed has the full middle name. We do not know that this is the same person.
Yep. Cross the T's, dot the I's.
Yeah. Yeah. So
might not do that on when you're pulling it off of the internet, just filling out a will.
Yeah.
Let me just write down what.
I mean, people all the time when they're filling in our questionnaire will fill in like, Dan McKenzie. Well, it's Daniel Ellis McKenzie. That's like right. On the birth certificate. On my title, I think that's what it was before I retitled to, though, my trust. So you gotta match up. So getting back to your question, I mean, it's like, yeah, they really want to keep it simple for the kid. I'm like, yeah, but we've got multiple people involved here and other lawyers looking at this, possibly a court. Like, we need to write some stuff in here that you're not going to understand. There's going to be citations to code and state statutes and language from cases that were decided in 1582 in England. And it's just like that kind of stuff really cannot be totally avoided. I want to keep it simple too. I'm not going to, come up with some crazy scheme for tying up money in trust for your kids if that's not what you want to do. But as far as like the trust document itself or the will, it's like, yeah, could you read this and explain everything? Like, I went to law school, done this for a long time. And it's like, it's still like, you got to take continuing education every year. And, I'm on several lawyer groups online. And it's just all day long, question. It's just like, and it's just common sense. It's just not right.
Well, and you just mentioned there are things that are avoidable and things that aren't avoidable. And you've seen firsthand how avoidable mistakes could tear families apart. What is the most common estate planning mistake you see families make?
I think there's a couple of things. One is I hear a lot people say like, well, you guys will figure it out. Let's just divide it equally and they will figure it out. And like, well, the person who is the personal rep or the trustee or whatever fiduciary position we're talking about, like, they don't get to just figure it out. They got to follow the instructions. So it's like, they might feel like, you know what, you did take care of mom. I really want to give you a larger share of this estate. Like, you deserve it. Well, there's another sibling there. It's like, you cannot play favorites. And this thing does not give you the latitude to do that kind of thing. So you can't just figure it out. You got to follow the law and what the document says. So that's always painful to hear. And then I think assuming that equal is fair, that equal, no one could fight over an equal distribution. Mm-hmm. And I would say the most, it is very common, especially when we've got adult kids and the person died at an age that most people, somewhere in their 80s or maybe even older than that. And it's like, yeah, they usually probably did need some help at the end. And it's almost always one kid steps up more than the other, and sometimes a lot more. And they're getting an equal distribution, and they feel like they do not like that. And then on both sides of that fight, I'm like, you're not like neither side is wrong. Like this thing does say equal, and you did a lot, but this doesn't give them the ability to, they could agree, I guess, but everybody's got to agree.
So does the term equitable come into play, or is it always equal?
I mean, there are several ways to handle that situation particularly, but no, I've never really seen equitable. I mean, you can give people discretion to do stuff within a document and just say, look, I'm going to leave it up to your discretion to decide this. But within that, you better be pretty clear about what they need to factor in. If they're using discretion to decide, like people will say this person should be compensated for doing this job, and it's at their discretion. It's like, okay, what are we factoring in here?
Got it.
I think that having, especially when there's siblings, and the parent will say, well, like you said, just half you, half your sister or brother, and thinking they'll never fight, they'll never argue. Like, seeing that death always causes such emotional turmoil. You just never know what happens in those situations. And have you ever seen it come out on the other end where things were okay? Or it just seems like setting that up in the beginning might be setting up for, I shouldn't say failure, but maybe more conflict than is actually necessary by having two siblings say, my children won't fight. Along all the time.
We hear that constantly. I would assume in most cases that probably true. Like most estates go fine. Like a large majority of estates probably get administered fine. But we do have a number of people who come through who are planning, and they also receive money from their parents. And a number of people who just say, like, I don't really talk to my sister anymore because of what happened during that whole problem. Like, they didn't go to court. It doesn't have to get to litigation. It's just like, really felt like she took advantage. And again, it's like it was an equal distribution, but she took too long to administer the estate, or she paid herself some excessive amount for her time, or she, something in the administrative phase can really, even with an equal distribution at the end, like just tons of fights about, whether you're getting all the information you're entitled to receive, whether the person really is moving fast enough. The most common source of fights actually in just about every contested probate I've had is somebody living in that house that is not an owner of the house. Every time someone comes in for estate administration and that factor is in there, this is not going to be good. Because that person who lives there feels like it's their house. They probably are there because they feel like they're taking care of the parents. The people outside the house are like, you were not, you were mooching, you've been mooching your whole life, and like you didn't do anything, and mom was living practically in squalor, and so forget that. And the person's like, I gave up my career. I've had situations where people are like, I was changing diapers, I was bathing, like real heavy nursing stuff.
Sure.
And feeling like, and one client is just like, the only reason there's an estate to even argue about here is because I did this. Mm-hmm. She would have had to go to a nursing home. This is ridiculous that it's equal distribution.
Emotions are high.
Yeah.
It's just so, yeah.
And the people outside, again, they had a story. Everyone has a story. No one's like, I'm definitely the bad guy here, but I'm going to do this anyway. Like everyone's like, no, I'm right. So that's where, again, I see people doing stuff where it's like they don't realize where the triggers are, or they, picking the right people to do the jobs. Everyone with kids who are adults defaults to one of those kids, a lot of times the oldest kid. And it's like, this is a real job. It requires real skills and responsibility, and the other kids better like respect them and trust them, and if they don't, it's gonna be bad. So picking the right person to do that job is probably more important than exactly what you tell them to do.
How many times do you see the family member having a conversation about, hey, look, I'm choosing you as my PR, my trustee, my whatever? How many times is that conversation happening versus the PR is actually surprised that they're...
I think it probably happens, but I get told it's happened more often than not. But I do warn people, like they could say yes, and the time comes and it's not a good time for them. So that's why we have backups. Or it could be like, this person's no good. And actually later on they develop into someone that could do it. So as far as talking to people always ask me, should I talk to people? I'm like, yeah, I generally think communication is good. But it still might be, I mean, we've got professional trustees out there, like, and a lot of them, like the larger, like Schwab or Fidelity or whatever else, like they will act as your trustee. And they've got all this language they want you to throw in the documents, making sure they have authorization to put the trust in a spot that lowers their liability, like Nevada, and follow Nevada law. And we can all, by the way, we can invest in our own products and all that kind of stuff. So they want all that stuff in there, and we put it in. And I haven't had this happen to me yet, but I've heard other lawyers say, yeah, we did all that. We did all the stuff they asked us to put in there. They put in there, and then the time came, and they were like, nope, we're not doing this. So even the because they're looking like, this has real estate in it. This has like, not very much money. Like our fees are going to be small. Like it's just not worth it to us. So even though you said we're going to be like, they don't have to take the job.
And so when you're having those conversations, how can elders start the conversation with their adult children without the death and morbidity coming into the conversation?
I think, again, like focusing on what is in it for them, which is getting back to that incapacity conversation and just making sure, the nightmare that I think everyone wants to avoid is ending up in some sort of like conservatorship or guardianship situation where a court is having to oversee somebody who's taking care of you. So we don't, like in Colorado, where we are, the probate process really isn't so bad. I think the consensus among estate planning attorneys here is that it doesn't always need to be avoided. And we actually do a lot of plans that are really not designed to avoid probate. They're just there to make the instructions clear and get the right people in place, but would require a probate process. Living probate, people always say probate is what happens after you die. Living probate is terrible. That is like, we are asking, like, if I run into a situation where it's like, my parents have not done this, they clearly need, they really are a danger to themselves at this point, or they're writing checks to everybody who asks for money. They are totally not able to do this anymore. And they haven't named me as a power of attorney. I can't get in anything. I'm going to need to go to a court. Mm-hmm. And in that situation, you are asking the court, like, if I give you a power of attorney, I can still do everything. Like when I use that power of attorney for my wife to close on the house, like she could have burst in the room and done it herself. It's just because she gave me power of attorney doesn't mean she couldn't also do it. It just means somebody else can also do it. In a conservatorship, you're telling a court, like, this person really can't do it anymore. You got to take away their rights to manage their own health care and their own finances and give it to me. So that obviously is a much bigger deal. Because if I'm telling my mom she's got to, go into this care situation that she doesn't want to go into, like, now a court has said, you got to do what he has said. You don't get to make the decision anymore. So courts are appropriately nervous about that and really put you through the ringer. And, you got to do a criminal background check. You got to do a credit check. You got to show up at the court. You might have to have doctors testify about their capacity. Again, the $600 an hour, like, you're in a court. Like now, when you get the conservatorship, you got to report at least once a year. Like there might be restrictions on how you can spend the money. Like it's just a totally invasive nightmare. And so getting back to the question, like, how do we encourage people to do this? Like maybe focus on that part of it. It's like, you do not want to end up in this situation. You want to choose this person, not have a court telling you like, oh, this kid that you actually is not your choice is going to be doing this. And so
you're in crisis mode. It's like at that point, the money that you're spending trying to make those decisions and trying to go through, like you said, what the courts are requiring, even for a living probate, doesn't sound like an easy process, and not one that somebody would definitely want to go through if they could avoid that. I mean, I know from a standpoint, my mother has said to me that, all right, all the stuff is in this spot in the house, but then later on I was like, so did you get an estate plan set up? And we've been having a conversation lately a lot about it, she's like, why is all this talk? I said, we're just trying to prepare in the things that we've experienced. And so she did. She finally got everything. She's in New York, so everything's been taken care of. But it was having that conversation. It wasn't just one conversation that we had, and she went, okay, let me go get this done. It was, having that conversation over and over. But if you don't have those or start early before you're in that crisis mode, it's kind of, you've seen the worst of it, right? So
yeah, it's usually not stuff you want to be doing, under the gun. And it's about maintaining control. People worry that they're giving up control, and I guess you kind of are, but you're really maintaining control. Like, at least I picked this person and gave them the instructions. And if you don't do that, like, there's still, it doesn't prevent you from dying. It doesn't prevent you from having these incapacity events. It just means like somebody else is going to make all the decisions, and hopefully they'll guess right at what you would have wanted, but there's no guarantee there. So yeah.
I think one of the things too, I've heard you mention you've had clients who will plan out everything, like from, what their funeral will look like. And so it's not just about, who's going to take over if I become incapacitated, or who's going to handle the estate, but they'll plan out everything, which, that's a planner.
Yeah, and I think that's usually appreciated. I have friends who do funeral planning, and they've told me, like, we've never had anyone plan their own funeral, and then the family finds out after they passed away that they did that. And I'm like, I really wanted to do that. It's expensive. Yeah, I compare it to like planning a wedding. Like, surprise, you got to plan a wedding this week, right? Like, it's pretty much all the same decisions. But
it can be super stressful.
Yeah, and everyone assumes that there's going to be fighting. It's going to be about money, so it's going to be about the will or power of attorney, and probably that is the case most of the time. But when families get into it, I mean, I've got stories from like that friend and other people about physical altercations at funeral homes. Like people getting out of chairs and swinging at each other over, because you're making permanent decisions like days after this traumatic event has happened, and everyone's like, why do you get to decide? I know mom wanted to be buried. No, she wanted to be cremated. Like, just stuff like that. Mm-hmm. And there's no compromise there. She's either getting buried or cremated. There's not like, well, we'll cremate her lower half and we'll bury the upper half. Like, no. No. So, and then end of life stuff too. That's the document we do is the advance directive or the living will, as far as like, how much treatment do you want? If doctors have determined, like, look, we're not really doing anything other than stopping you from dying at this point. Do you want us to keep stopping that or not? Mm-hmm. And again, families, if you pull in everybody, usually there's somebody who's like, let's not give up hope just yet. And other people are like, this is $10,000 a day.
Yeah. Well, you mentioned advance directives. Are there other key documents that our listeners need to be aware of while they're still alive, like that prep kind of mode?
So the powers of attorney, so you got a financial power of attorney and medical power of attorney. Those are lifetime documents, and the living will. Those are kind of your 3 lifetime documents. People confuse the living will with a DNR. I get that question all the time. Like, is that the DNR? The DNR is a do not resuscitate. Do not resuscitates are usually for people who are fairly advanced age and also have a declining quality of life because they're sick or have some sort of pain, and they're just like really not doing much and just in a lot of agony and feeling like, look, if you come into this room and find me unresponsive, like, don't start. Let me go. Do not crack my ribs giving me CPR to bring me back to this, because this is no good. I'm not doing this anymore if I don't have to. So like I say, usually like 85-year-olds plus or have DNRs. I've had people younger than that, but it's like, again, it's like you can be resuscitated and be totally fine. That happens all the time. So, if you're 70, I every once in a while I run into somebody who's younger, like quite a bit younger. I'm like, really? You don't want to be resuscitated? That's something. That has to be signed by a doctor. State statute says it has to be on a green form. There's a particular shade of green, and you might wonder why. Because EMTs are trained to, if they burst into a house and find someone unresponsive, the first thing they do is check the fridge to see if there is a green form on the fridge.
Interesting.
Because if you have a DNR, you probably want it, like, if they resuscitate you, it's like, crap. So people have like tattooed it on themselves. It's, probably not legally enforceable. But yeah, and when people are really opinionated about, like, I definitely do not want to be resuscitated. Like that's
commitment to have
that is the yeah. Oh yeah. The living will is the other way around. This is like treatment has been started. You are not responsive, and now the question is, should we stop? So that can happen to anyone. That can happen to a 20-year-old. You can get in a car accident, have some sort of brain injury, or have some sort of cancer or something like that that is like clearly closing in on the end here. Do you want us to keep going? And so we do that one. And like I say, any adult should probably have that in place.
Is there also an element of like the medication rules through that process? Do I want to continue receiving my medication versus it's not a resuscitation thing, but is there directives that someone can make on don't continue?
On the living will, it's like pretty specific conditions as far as like 2 doctors have to have evaluated you and determine like this is only postponing the moment of death. So it depends on whether that medication is just doing that. If it's having other positive, probably not. The other question we get asked, like there's 3. So there's the DNR, there's the living will, and then there's assisted suicide, which I get asked about occasionally, which was authorized in Colorado at some point. I don't know if I feel like it's been used, but very sparingly. But that, again, very specific circumstances where you got to have the terminal condition, have a psychological evaluation, be able to administer it to yourself. Like, there's some very, this is not just like, okay, this person's unconscious. It's a different situation. So it fairly tight and doesn't cover several things like that. Right? Just like, I'm going to stop this medication and see how that goes. Probably not.
And what about the eating and drinking? If someone stops, if I stop eating or drinking, can it be forced? And is that part of that directive as well?
You probably are talking, that usually is. Like when people are really close to death, that is like one of the signs. They do stop eating and drinking. So in the living will, again, that is one of the questions, and they separate that out from medical treatment. So would you want medical treatment stopped? Would you want artificial nutrition and hydration stopped? Those are 2 different things. People feel differently about that, but that's artificial. Again, you're not responsive and couldn't feed yourself, so it's being pumped into you. The situation you're describing where the person could feed themselves and are just choosing not to, there is kind of a movement out there to deal with like people who have dementia and Alzheimer's, because this doesn't cover them, and they can really get into a position where it's like this is not a dignified life anymore. Like, they would not have wanted this. It's not covered by the living will because they're not. That's not really necessarily a fatal disease, right? It's not like immediately that you're dying. And like if you could hold if a nurse can hold a spoon, if they can put fluid in them, should they do that? The living will is really not applicable there.
If we have listeners out there who may feel intimidated or maybe ashamed because they have not yet started the process or the planning, what would be your message to them?
You're in the majority. We think. It's hard to tell exactly because wills, like in Colorado, like you do your will, you do not register with the court. That used to be a thing you could do. They don't do that anymore. So if you have somebody's will and they've passed away, at that point you're supposed to turn it over to the court. But, we don't really know exactly how many people are out there with or without wills. I think the estimate is like 70% of people pass away without any will in place. So it is a pretty large majority. So it's not anything to feel bad about. And I always tell look, you have an estate plan, and it's not just like the intestate, like you've got state rules that say, here's how this is going to go. If you do not have a plan of your own, here's what's going to happen.
Dan, thank you so much for a clear and empowering conversation. You've reminded us that estate planning is about love, protection, and preparation, not fear. It's about giving our families the gift of peace and clarity when they will need it most. If today's episode sparked questions or gave you the nudge to finally start your plan, visit themckenziefirm.com or call 303-578-2745 to connect with Dan and his team. They offer compassionate, comprehensive guidance to help you create a plan that truly fits your life and family. We'll also link Dan's contact information in the show notes, along with resources to help you start the conversation with your loved ones. And remember, empowerment starts with clarity. Take one step today towards creating the future you want for yourself and those you love. This has been another episode of the Empowered Elder Podcast with your hosts, Tasha Beckman and Nicole Robilotto. Until next time, keep living, planning, and aging with purpose.